Good evening, aspirants. So today we are going to deal with Directive Principles of State Policy, that is DPSPs, from the book Indian Polity by M. Laxmikanth. Okay, so what are DPSPs and where are they found? DPSPs are enumerated in Part 4 of the Indian Constitution from Article 36 to 51. And this idea of DPSP is from the Irish Constitution, and in which the Irish Constitution they copied this idea of DPSP from the Spanish Constitution. The Directive Principles, along with the fundamental rights, contain the philosophy of the Constitution. Okay, so let's move on to the features of Directive Principles. Directive Principles of State Policy denotes the ideals that the state should keep in mind while formulating policies and enacting laws. So DPSPs are the ideas that the state should keep in their mind while formulating some policies or some laws. And these are the constitutional instructions or recommendations to the state in legislative, executive and administrative matters. Okay, and according to Article 36, the term state in Part 4 has the same meaning as in Part 3 dealing with the fundamental rights. Okay, and then comes DPSP resembles the instrument of instruction. Yes, the idea of DPSP has been there in India while the Britishers ruled India, but during that time these were the instruments of instructions which were given to the Governor General and to the governors of the colonies of India by the British government under the Government of India Act of 1935. And after that it was modified, and the same thing came as Directive Principles, and the only difference is that they are instructions to the legislature and the executive. Okay, so then comes its and the DPSPs aim at realizing the high ideals of justice, liberty, equality and fraternity as outlined in the preamble of the Constitution. Also, they embody the concept of welfare state and not that of a police state. Okay, so the important feature of DPSP is that DPSPs are non-justiciable in nature, that is, they are not legally enforceable by the courts for their violation. Okay, and also in Article 37 itself they say that these principles are fundamental in the governance of the country, and it shall be the duty of the state to apply these principles in making laws. So DPSPs are non-justiciable, but that's not in the case of fundamental rights. Fundamental rights are justiciable, and we will talk about it in later. So DPSPs are non-justiciable in nature, that is, they cannot be legally enforceable by the courts for their violation. So then comes the classification of Directive Principles. So the DPSP, the Directive Principle, is classified into mainly three categories. That is, DPSPs has ideas from socialistic, Gandhian and liberal intellectuals. So there are three categories of principles in DPSPs. So we will move on to the first one, that is the Socialistic Principles. So in this, they direct the state to promote the welfare of the people by securing a social order permeated by justice, social, economic and political, and to minimize inequalities in income, status, facilities and opportunities as in Article 38. So then it moves to it directs the state to secure the right to adequate means of livelihood for citizens, their health situations, equal pay for equal work for men and women, and so on. Then the other important thing is that to promote equal justice and to provide free legal aid to the poor as in Article 39A. Then comes to secure the right to work, to education and to public assistance in case of unemployment, old age, sickness and disablement as in Article 41. Okay, so then they also direct to secure a living wage, a decent standard of life and social and cultural opportunities for all workers as in Article 43. So, and the other important idea in Socialistic Principles is to take steps to secure the participation of workers in the management of industries as in Article 43A, and the last one is to raise the level of nutrition and the standard of living of people and to improve public health as in Article 47. So I hope that it's not necessary to explain all these things as these are the articles. So you guys should take refer the textbook, or you can just pause the video and you can read these articles in this video, because it's such a waste of time. So we'll move on to the Gandhian Principles. So as from the name itself, it is clear that what is meant by Gandhian Principles. These were the ideas of Mahatma Gandhi. So they require the state to organize village panchayats and endow them with necessary powers and authority to enable them to function as units of self-government, as in Article 40. Then the other important thing in Gandhian Principles are to promote the educational and economic interests of SCs, STs and other weaker sections of the society, and to protect them from social injustice and exploitation, as in Article 46. Then the important other two, there are two more important principles in this, that is to prohibit the consumption of intoxicating drinks and drugs which are injurious to health, as in Article 47, and to prohibit the slaughter of cows, calves and other milch and draught cattle to improve their breeds, as in Article 48. So we move on to the last principle, that is the liberal intellectual principles. In this, the principles include in this category represent the ideology of liberalism. So they direct the state to secure all citizens a uniform civil code throughout the country, as in Article 44, and also it provides early child care and education for all children until they complete the age of 6 years, as in Article 45. Then in liberal and intellectual principles, they also say to protect and improve the environment and to safeguard forests and wildlife, as in Article 48A. Also in this, they include to protect monuments, places and objects of artistic or historic interests which are declared to be of national importance, as in Article 49. Then to separate the judiciary from the executive in the public services of the state, that is in Article 50. And the last one is to promote international peace and security and maintain just and honorable relations between nations, to foster respect for international law and treaty obligations, and to encourage settlement of international disputes by arbitration, as in Article 51. So then now we move on to new directive principles. So in new directive principles, some more new directive principles were added in the coming years. So the first one was in the 42nd Amendment Act of 1976. They added 4 new directive principles to the original list, and they are to secure opportunities for healthy development of children, as in Article 39, to promote equal justice and to provide free legal aid to poor, as in Article 39A, and to take steps to secure the participation of workers in the management of industries, as in Article 43A, and to protect and improve the environment and to safeguard forests and wildlife, as in Article 48A. Then in the in 44th Amendment Act of 1978, they added one more directive principle which requires the state to minimize inequality in income, status, facilities and opportunities, as in Article 38. Then in the 86th Amendment Act of 2002, they changed the subject matter of Article 45 and made elementary education as fundamental right under Article 21A. And in the 97th Amendment Act of 2011, they added a new directive principle relating to cooperative societies. And through this, they require the state to promote voluntary formation, autonomous functioning, democratic control and professional management of cooperative societies, as in Article 43B. So then the other section is sanction behind directive principles. You can read it, nothing much to say about it. So we'll move on to, I'm sliding slowly so that you can pause the video and read it. We'll move to criticism of the directive principles. And in this section, it's a criticism of the directive DPSPs. So it is divided into 4. So the first one is no legal force. So the directives have been criticized mainly because of their non-justiciable character. So you can read it. And the second one is illogically arranged. Critics opine that the directives are not arranged in a logical manner based on a consistent philosophy. You can read it according to N. Srinivasan. The directives are neither properly classified nor logically arranged. So then comes the conservative. And according to Sir Ivor Jennings, the directives are based on the political philosophy of the 19th century England. So he states like this. And then the last one is the constitutional conflict. It's such as the case Antanam has pointed out that the directives lead to a constitutional conflict, such as the conflict between centers and the states, and between president and prime minister, and between the governor and the chief ministers. So according to him, the center can give directions to the states with regard to the implementation of these principles, and in case of non-compliance can dismiss the state government. Okay, so then we'll move on to the utility of directive principles. Okay, so in utility of directive principles also you can read it, nothing much to explain about this. And in this they say some key features of the directives, and some are like they are instrument of instructions, as we said earlier, such as or general recommendations are addressed to all the authorities in the Indian Union, and they have helped the courts in exercising their power of judicial review, that is the power to determine the constitutional validity of a law. And also they also play other roles, such as they facilitate stability and continuity in domestic and foreign policies in political, economic and social spheres in spite of the changes of the party in power. Also they serve as a crucial test for the performance of the government, and they serve as common political manifesto. A ruling party, irrespective of its political ideology, has to recognize the fact that these principles are intended to be its guide, philosopher and friend in its legislative and executive acts. So we move to conflict between fundamental rights and directive principles. This also you can read, in this section we go through many cases where there was a conflict there were conflicts about the DPSPs and fundamental rights. So first it comes the Champakam Dorerajan case. It was in 1951, and in this case the Supreme Court ruled that in case of any conflict between the fundamental rights and the DPSPs, the former would prevail. That is, they declared that fundamental rights could be amended by the Parliament by enacting constitutional amendment acts. Okay, then comes the Golaknath case in 1967, and in this case Supreme Court ruled that the Parliament cannot take away or abridge any of the fundamental rights which are sacrosanct in nature. In other words, the court held that the fundamental rights cannot be amended for the implementation of the directive principles. Okay, so then we move to the next case, that is the landmark case of Keshavananda Bharati case in 1973, and in this the Supreme Court declared the above second provision in Keshavananda Bharati case of 1973, the Supreme Court declared that Article 31C as unconstitutional and invalid on the ground that judicial review is a basic feature of the Constitution and hence cannot be taken away. However, the above provision of Article 31C was held to be constitutional and valid. Later in the 42nd Amendment Act of 1976, it extended the scope of Article 31C by including within its protection any law to implement any of the directive principles and not merely those specified in Article 39B and 39C. Then comes the case of Minerva Mills case in 1980, and it means that the directive principles were once again made subordinate to the fundamental rights. But the fundamental rights conferred by Article 14 and 19 were accepted as subordinate to directive principles specified in Article 39B and 39C. Further, Article 31, that is the right to property was abolished by the 44th Amendment Act of 1978. Okay, so then they also say that therefore the present position is, what is the present position of fundamental rights and DPSPs? The present position of fundamental rights enjoys supremacy over the DPSPs, yet this does not mean that the DPSPs cannot be implemented. The Parliament can amend the fundamental rights for implementing the directive principles so long as the amendment does not damage or destroy the basic structure of the Constitution. So here the word basic structure is very important, you can read it. So then we move to the implementation of directive principles. Directive principles have implemented many things. So some are such as the Planning Commission was established in 1950, and they came up with successive 5-year plans associated with securing socio-economic justice and reducing inequalities of income, status, and opportunities. And later in 2015, the government replaced the name of Planning Commission into Niti Aayog, that is National Institution for Transforming India. Then they also came up with abolition of intermediaries like Zamindas, Jagirdas and Inamdas, etc. Tenancy reforms like security of tenure, fair rents, etc. Imposition of ceilings on land holdings, distribution of surplus land among the landless labourers, and cooperative farming. Then they came up with many acts such as the Minimum Wage Act, so and so you can read it. Then the Maternity Benefit Act, Equal Remuneration Act for women, and so such as they made nationalization of life insurance 1956, then the Legal Services Authorities Act of 1987. Then the other important thing is the Wildlife Protection Act of 1972 and the Forest Conservation Act of 1980. Okay, then three-tier Panchayati Raj system at village, taluk and Zilla levels has been introduced to translate into reality Gandhiji's dream of every village being a republic. The 73rd Amendment Act of 1992 has been enacted to provide constitutional status and protection to these Panchayati Raj institutions. This was also done by the DPSPs and the National Commission for Protection of Child Rights 2007. And this is important, the Criminal Procedure Code 1973 separated the judiciary from the executive in the republic in the public services of the state. Okay, so also they also made the Ancient and Historical Monument and Archaeological Sites and Remains Act 1951 has been enacted to protect the monuments, places and objects of national importance. So you can read this, nothing much to explain. So this moves to directives outside part 4. There are many directives outside part 4 in the constitution, such as the claims of Supreme Court, scheduled caste and scheduled tribes to services, and instruction to mother tongue, that is, it shall be the endeavor of every state and every local authority within the state to provide adequate facilities for instruction in the mother tongue at the primary stage of education to children belonging to linguistic minority groups, as in Article 350A in part 17. So development of Hindi language, you can read that. So that's it. So that's it about DPSPs. You can read the rest of the boxes and notes and references. I'll slide slowly. You can pause the video and read it. So that's it about DPSPs. It's been a long time, I know that. Sorry. So we'll be continuing to upload such videos. Thank you and all the best. Have a nice day. And actually, I was not able to highlight the notes in this PDF. I'm really sorry about that. Next time it won't happen. And so that's it. So thank you.